In the last legal series, I talked about the insured's obligations under the insurance contract, but under an insurance contract, obligations go both ways, and an insurance company owes obligations to an insured and owes the duty of good faith in performing those obligations. As I work with accident injuries and injury victims, one of the more common misconceptions that I run into is the question that revolves around the idea of who is responsible to the victim of the accident. And most people want to think that it's the insurance company of the other individual who's at fault for the accident, because it's the insurance company that's financially responsible, and it's the insurance company that usually deals with those individuals. So when people come and visit me, they're upset at the insurance company for the way that they've been treated, the way that they feel that they've gotten a runaround, and so they want to file suit against the insurance company of the other individual. However, it's not the insurance company that's responsible. It's the individual who actually caused the accident who's going to be responsible. The insurance company is just the money or the financial backing of what happens when an individual is careless or negligent on the roads. So instead of being responsible to the individual who is the accident victim or the injury victim in a vehicle accident, the insurance company is going to be responsible to the person who has insurance with that company. So when we talk about obligations and duties of an insurance company under an insurance contract, what we're talking about is those duties and obligations that are owed to the insured. In Arizona, every insurance policy is presumed to have a covenant of good faith and fair dealing. That is a covenant that is automatically implied into the insurance policy by law, even if it is not specifically written out. And basically what that means is that an insurance company is expected to act both honestly and fairly under the terms of the insurance contract. In the last legal series, I explained that insurance contracts are essentially contracts of adhesion. The reason for this is because the insured under an insurance policy really has no bargaining power. The insurance company is left with all of the power to make all of the terms, unless the terms are absolutely required by Arizona law, which some are. So other than that, the insurance company is going to have all of the bargaining power. And under the insurance contract, insurance companies have given themselves the power to be able to determine whether or not an insurance claim is going to be paid. So because of that unequal power between the insured and the insurer, Arizona law is going to require that they act both in good faith and in fair dealing, meaning that they're going to be both fair and honest under the terms of the contract that are written out. Once an insurance company receives notice of a claim, they have the duty to promptly respond and to investigate the claim. Sometimes the investigation of a claim is going to include coverage matters. Most investigations are going to include an investigation into the facts surrounding what the claim is. The insurance policy requires that the insurer defend the insured. Typically that obligation is going to be triggered through the filing of a lawsuit. Another obligation that the insurer has under the insurance contract is to settle claims that are made against their insured when appropriate to do so. They have the duty to investigate into the claims and to make the determination when it is appropriate to settle instead of having their insured involved in a lawsuit. Now, keeping in mind that the insurance contract requires the insurance company to act in good faith and in fair dealings, they have to take their insured's interests into account as well. Essentially what the term is that they must give equal consideration to the insured's interests as they would to their own interests. The last bit of information that I'll share with you is that under an insurance policy, an insurance company is going to be obligated to indemnify the insured, or in other words, they're going to be responsible for reimbursing the insured for covered expenses that the insured incurs as a result of a loss, or is going to be required to pay for the expenses or the costs that an insured becomes legally obligated to pay to others. I hope that you find this information helpful. As always, if you have any questions or need assistance legally, please call Curry, Pearson & Wooten.